different geographic factors and emblematic or qualitative factors. The evidence you're going to hear over the course of this week and next will leave no doubt that the targeted part of the Rohingya group was by reference to these three elements, and it was substantial. I turn next to the need to establish the presence of the dolus specialis. As the court has made clear, this can be either on the basis of direct or indirect and circumstantial evidence. The court clarified its approach to identifying the existence of dolus specialis. It said, and I quote, "In the absence of a state plan expressing the intent to commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent." End of quote. Now, those are words, no doubt, we're going to be coming back to. On the basis of overt, that is to say, written incriminating evidence of a general plan. But for understandable reasons, perpetrators have tended to avoid that approach. And so the court, very wisely, we say, has recognized, has affirmed, that it can proceed by reference to circumstantial evidence in two distinct situations. First, by reference to particular circumstances which are convincingly demonstrated, or second, by reference to a pattern of conduct which could only point to the existence of the special intent. In the context of this application, as the evidence on the court's record establishes and as will be addressed by my colleagues this week, there are particular circumstances which convincingly show that Myanmar and its state organs acted with genocidal intent against the Rohingya. And that is especially clear in the case of at least three individual Chut Kien and Mang Nu, the harrowing accounts of which will be presented to the court tomorrow morning. Just as in Srebrenica, in the Bosnia case, the particular circumstances of what happened in those three villages, the concerted violence and devastation, the disproportionate and utterly inhuman treatment of the Rohingya who lived there, the widespread sexual violence, and even the targeting of Rohingya children, present, we say, the inescapable conclusion that the crimes against the Rohingya who lived there were perpetrated with genocidal intent. To be clear, we say that those three villages also formed part of a pattern, a wider pattern of conduct, which extended to dozens of other locations in northern Rakhine state, and from which genocidal intent is the only inference that could reasonably be drawn from the acts in question. That does not mean, however, as I've already submitted, that in relation to a pattern of conduct, it has to be the only motive. What it means is that on the it would be unreasonable to conclude that an intent to destroy the group in whole or in part did not exist. And in this case, that test is plainly met. The pattern of conduct across the various locations identified in northern Rakhine is only explicable, we say, on a reasonable basis by the existence of a genocidal intent acted upon by Myanmar. when the court considers, as it must, all of the evidence taken together, the only reasonable conclusion to reach is that a genocidal intent permeated and informed Myanmar's myriad of state-led actions against the Rohingya. Now, we note that Myanmar, in its rejoinder, accepts and agrees that genocidal intent can operate alongside and simultaneous with other motives. The interveners also agree with that. Indeed, the court has itself recognized that certain acts performed without genocidal intent may nevertheless also assist in deducing the existence of a genocidal intent. For example, in the Croatia judgment, the court held that acts, and I quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention, and may be significant as indicative of the presence of a special intent inspiring those acts. End of quote. This makes it clear in our submission that both such intentions, ethnic cleansing and genocide, and maybe other crimes, may coexist. And in this regard, I refer you to the intervention of the Republic of Ireland and to Judge Bandari's helpful separate opinion in the Croatia case to explain the point. What this means is that for a pattern of conduct to point only to the existence of genocidal intent is not to say that it could point to such intent only. This is how Ireland has put it. And Ireland is, of course, a land of remarkable writers, thinking of James Joyce and Seamus Heaney and Colm Tóibín and Fintan O'Toole, writers who really know about the power of words. And their lawyers have done the same thing. This is how they put it. The human mind can, of course, accommodate and act upon more than one intention. And the same conduct can be intended to achieve two or more results, however attainable each may be. It follows that it is perfectly possible that a pattern of conduct upon examination could point to two separate intentions, only one of which is genocidal. This possibility was recognized by Judge Bandari in his separate opinion in the Croatia case, wherein warning against conflating punitive motive with genocidal intent, he noted that genocidal intent may exist simultaneously with other ulterior motives. This approach, which recognizes and takes account of the reality must reflect the actuality of how human beings are and why they act, individually and collectively through the state. What makes them, what makes us do terrible things to other people. While the Gambia recognizes that it's the attributed attention of Myanmar that matters in this case, and not that of each individual perpetrator on the ground that has to be established, it also cannot be overlooked that a state acts through people. The court, in seeking to determine whether genocidal intent is the only reasonable inference to be drawn from a